Our hearing about the tax settlement with Google in particular, but because we've got now HMRC in front of us, we're hoping to broaden it out to look at wider tax settlements. So we have as our witnesses Jim Harrer, the Director General for Business Tax at HMRC, Her Majesty's Revenue and Customs, Dame Lynn Homer, the Permanent Secretary at Her Majesty's Revenue and Customs. It might be your last outing in front of us, I think, Dame Lynn. And Edward Troop, the Tax Assurance Commissioner at HMRC. But before we start, though, into the main session, Dame Lynn, we were concerned as a committee to receive a letter from you late yesterday afternoon, when we were actually in committee, offering to reveal to us privately information about the tax settlement with Google. Can I ask, first of all, did you coordinate that letter did you talk to Google about that letter before you sent it to us?
Well, Chair, I think you received a letter from me on Tuesday sharing some information with you and referencing... No,
we received a letter yesterday.
You received a letter from me on Tuesday sharing some information with you as a committee, which we were able to share under our own steam.
So that was the stuff you put on the website, on the gov.uk website.
And some additional information.
I'm talking, Ms. Damon, sorry, I'm talking about the letter that arrived yesterday from HMRC.
On Tuesday,
so I'm talking about, sorry, Dame Lynn, I'm just asking about a letter that arrived with us yesterday. That's what I'm asking about.
No, I am about to answer your question. Yeah. The day we also shared some information with you the evening before yesterday, indicating that we may be able to share some taxpayer confidential information with you confidentially. But whilst we offered that to you, we also went back to Google with our advice that it would be better if they were prepared to share that publicly. I don't know why you're arguing about this point. I'm not really trying to pick an argument with you on the date on which a letter arrived. Good. We received a letter yesterday while we were in committee. So we were in committee, so we remember it arriving because we were busy doing something else. That was the third letter from me.
Well, this is the letter the letter I'm talking about then.
Yes.
Is the letter we received yesterday in which you offered to share information with us about the HMRC and Google settlement or deal. Yes?
That was the third letter, and that offered, we got consent from Google, which we got just shortly before that letter, to disclose taxpayer confidential information to you.
That's we could have got here. Sorry, if you just answered my first question, Dame Lynn, we could have got to that point much sooner. So you did coordinate with Google about the letter you sent to us yesterday to reveal information that you were offering to reveal information.
We wrote the statement. We asked for their permission to share it, which they gave us yesterday.
Fine. Okay, that's all I needed. We could have got here 5 minutes quicker. But can I be really clear to you that we're having this committee hearing today not for our own personal benefit, but because we want answers about this in public, so that the taxpayers who are our constituents hear the answers too. And partial, late information in confidence just doesn't do that. It didn't give us any chance to do anything with it. So we're going to disregard that today. We haven't seen any confidential information, and we are going to talk to you openly and publicly, and we hope that you will all be clear and precise in your answers. Bearing in mind, as I'm sure you are, I don't need to remind you, you're public servants, and it's the servants of us all that we're trying to get questions from, answers on. So, I was disappointed at that approach, frankly. It was not very helpful to the transparency of our process. Can I just kick off then to you and ask, first of all, how much did it cost HMRC? Actually, I think maybe Jim Harrer might be the person to answer this one. When you spent 6 years investigating Google. We've heard quite a lot of detail about what went on in that investigation. How much did it cost HMRC and the British taxpayer?
Yes, we don't hold our information in the way that enables us to do that. It went on over 6 years at various stages. Different people were involved in it at different times, but obviously conducting a 6-year audit is a very expensive and resource-intensive process for us, which I wish we didn't have to undertake.
Okay, so have you got a ballpark of, did you do an opportunity cost of taking staff off other things to go and do this?
No, we didn't. I mean, what we do is we do a risk assessment and deploy our resource to risk. In the case of large businesses, the yield-cost ratio is about 75 to 1. If you take the cost that
So the yield-cost ratio is 75 to 1?
In large business inquiry work, yes.
Okay. And in doing this long 6-year investigation, and I'm going to bring in Deirdre Brockett in a moment on this issue, it seems it took a long time to get to the bottom of something that we have raised here in this committee and other people have been raising for some time about the challenge of taxing internet giants. But why did it take 6 years? Was there not a way of doing it faster so that you could actually collect tax in real time?
Yes. Ideally, corporates would take a lower risk approach to their tax planning and would deal with us in real time, and we wouldn't have to do 6-year audits into back tax. It does not, although transfer pricing inquiries do actually take longer than most other inquiries to carry out, they do not normally take 6 years. I think Mr. Britton explained some of the reasons why this one took so long. First of all, it is a new area of the economy. There are a number of tax authorities in a coordinated way looking at this and sharing intelligence and ideas, and we are a member of an international project of 6 tax authorities looking at digital giants in particular, so we were sharing lots of information during that time. Also, it is the nature, I think, of digital companies like Google that over time their scale and their business model and the way they and their customers behave change all the time. So Mr. Britton mentioned, for example, the exponential growth in the size of the UK operation. So that means we can't just look at 1 year and then apply what we learned to that year, extrapolate that to other years. We've got to look at each year individually and look at how things change during that period. So it was a very resource intensive and long inquiry and painstaking to get to the bottom of things.
Okay, we're going to get into a bit more detail about the inquiry and about relative resources, but I'm going to ask Deirdre Brock to kick off with this. Okay.
Yes, as the Chair said, it's the deals took 6 years to finalise. Can I ask what the main sticking points for HMRC were during that time?
So how we conduct these inquiries is, first of all, there is a sort of thorough and painstaking review of the facts. As Mr. Britton mentioned, in this case that meant not only looking at what goes on in the UK and interviewing the group's employees from the very top through to the people doing the work.
That's the process. I'm just wondering what the main sticking points, what were the main areas that you had big discussion over that caused this
I think the two key areas in an inquiry like this are, first of all, establishing the facts of what goes on in the different jurisdictions, the activities that are carried on and the assets that are located there year by year, then looking for comparable data using the different methodologies that we might use.
That's again the process. What are the main arguments that you had with Google that delayed the final decision and to arrive at the amount that you arrived at?
Once you've established the facts, the kind of discussion that you have is about what value add is created by activities, what kind of remuneration those activities get on an arm's length basis in the market, which transfer pricing methodologies are the relevant methodologies to apply, and so if you look at several of them, what ranges do they give? And as was mentioned in this case also, whilst there is clearly a UK company to which we can attach a tax charge, whether in fact there was a permanent establishment of some other Google company in the UK.
Taxpayers are very angry at the whole process and how long it's taken and how opaque it appears to be. I'm wondering, Dame Lynn, why can't we be told how that figure of £130 million that you've arrived at is broken down, what the methodology that you used was?
I think on the back of the agreement we got yesterday from Google, Jim can tell you more information than we're normally able to. So just to go back to the Chair's point, I totally accept the point that it would have been better if we could have told you earlier.
We just need to answer Deirdre Brock's question.
We asked for the information to be capable of being shared in order to be able to tell you a little bit more about it. So the taxpayer confidential information, which, by the way, our letter to you last night said can be public.
Right.
So it was not confidential. The note last night was...
But it's only public because we're having this hearing. That's the concern I think Ms Brock is trying to raise.
And that's the concern of the taxpayers.
So
they don't understand why this is happening behind closed doors.
Well, because of the law. And I think Mr Bacon referred to a number of hearings, as did Ms Hillier. I think both of you were here at the hearings in 2012. Under the Act, which we are ruled by, we are obliged to keep taxpayer information confidential. I think your previous witnesses illustrated some of the reason for that. There are elements of commercial sensitivity if you lay all of a company's business on the table. But I would say in practical terms as well, the benefit we get as when we do inquiries is that knowing that they are sharing with us, not, if you like, with their competitors.
But can I just say, we don't actually need to know the earnings and the tax details of everyone and every company, but we do need to know that HMRC is treating everyone fairly.
Yes, of course you
and
do.
at the moment, it's very difficult for anyone to be able to figure that out, be it for any of the taxpayers that watch on in these sorts of situations in bewilderment, frankly,
This is also
at how you arrive
something-
at these figures.
This is also something that we have discussed with you at length. It was an issue which I grappled with immediately after I was appointed 4 years ago. You'd had a hearing then. You had challenged us about whether our processes and our governance were strong enough and good enough. I think Mr. Bacon referred to our architecture needing change. I think Ms. Hillier referred to us needing to be much better at creating separate roles. I put in place a new governance and a new structure which is designed both to account to you, Edward, as our Tax Assurance Commissioner, reports annually, and to be subject to audit, both by our own internal audit and our Audit and Risk Committee, but also as part of our annual audit with NAO. So we have done our best,
Quick, just
but
one last
statutorily
question,
we are
Chair.
still obliged
I appreciate
to keep
that. But what would
We know
normally
what's
happen to, say, a sole trader? I've got many businesses in my constituency who's, say, running a corner shop, whose tax affairs aren't sorted out for years on end. What would happen to them normally?
Well, thank you very much. I mean, I would like to take the opportunity to say it is exactly the same system we apply to everyone. So people who are in the area where we start with the self-assessment, which will include many small businesses as well as big, they come to us and they tell us the tax they think they should pay. With many small businesses, we will then agree that and take that tax. With large businesses, at any one time, 2/3 of them, we say, before we agree that, we want to root about in it and make sure you're right. And in about 12% of small businesses, we do that. We then apply exactly the same approach to expecting back payments and penalties across all businesses.
But this particular approach took 6 years.
On average, our transfer pricing takes 22 months. So yes, this is a long one. And yes, there are some small businesses where it can take us a number of years to arrive at a settlement. But in the main, for most people, it is a much quicker process. But it is exactly the same process.
Okay. Caroline Flint.
The fact that Google have paid £130 million, of which 18 million is in interest payments, does that reflect that they did not pay enough tax?
I'll ask Jim to answer.
Yes, it clearly does. I mean, I think if you look at their accounts from 2005 to 2015, the total charge they've taken for corporation tax and interest is £196.4 million. They have acknowledged that 130 million of that is as a result of our investigation, which is a very significant uplift in their liability. And in fact, I believe that 130 million understates the impact of our inquiry, because if you look at their accounts from 2012, they acknowledge there that they are going to have to pay more, and they already start charging more in their accounts in 2012 and 2013. So of the tax and interest that they have paid over the last 10.5 years, a very substantial part of it arises as a result of our investigation.
Thank you, Mr. Hara. If that is the case, why hasn't HMRC applied any penalties to Google for non-payment of tax?
Yes, I think penalties and large businesses are quite a challenge, and I'll describe in a second what the government is doing about that. In order to attach a penalty, we have to demonstrate two things. First of all, that the return was wrong, and it clearly was in this case. And secondly, that insufficient care was taken in producing the self-assessment. And the challenge, for example, in transfer pricing is, as previous witness said, they can take a lot of expert advice and opinion. They can take a reasonable position in relation to a complex area of law. We can challenge that, and they can accept that they need to change their position. But it is very difficult to establish that they've taken insufficient care. We have a penalty consistency panel that applies specifically to large businesses to make sure in every case where we get a significant uplift in profits, we apply a penalty if we possibly can. And we've published draft legislation in the Finance Bill 16 to remove that reasonable care defence from large businesses who are habitually aggressive tax planners and who habitually understate their profits as a result.
So, Mr. Hara, I mean, basically their lawyers and their tax people have outmanoeuvred HMRC with a story to tell about why they shouldn't face payment. You can understand why the public, whether that's individual taxpayers or businesses, do find it hard to believe that in your own words, sorry, if I could just finish, thank you. That in your own words, they did not return a proper tax. return, and the fact they hadn't paid the tax they should have done, but apart from the interest, they haven't faced a penalty.
I do understand
public anger at that, because it just seems if you've got enough hard guns in the form of lawyers and tax people, big companies can get away with it.
I do understand that anger, and I think HMRC's position and the government's position is that the current penalty legislation does not work in relation to large businesses in the way that it should.
And that must have been around for some time, because actually we're talking about Google today, but I noticed Gap were being looked at in the Evening Standard last night when I looked at the business.
The penalty legislation's been there since 2007.
There's a whole number of companies for whom that. Can I ask you, does the fact that my colleague Mr. Moat mentioned about the Dutch sandwich, the double Irish, and we'll have to think of something for the Bermuda Triangle. That's all I can come up with right now. But
picnic for the
does the existence of this structural way in which they organise their finances in Bermuda have an impact on tax paid in the UK? Because we couldn't really get a clear answer from the Google representatives.
I think the previous witnesses did give an answer to that, which I agree with. The starting point that we take is what are the activities that are carried on in the UK, or what are the assets that are produced that are held in the UK? What value do they create in the group's profitability, and are we getting sufficient profits returned that reflects that value? So if they have an asset held in Bermuda, which, as they said, is designed to make sure that profits don't get back to the US and get taxed in the US, that's not material to the UK. The key thing that I have to do is to make sure that all UK activities get taxed at the full value that they bring.
You noticed in the questioning that I in the last session that I quoted the fact that Google was saying that, although they're in the terms of the past, they look at their profits in terms of what they should pay tax, they're taking much more, going forward they'll be looking at their sales activity as well, and they got into a discussion about that. How will that change the amount that they will pay in tax?
Well, I think for the future, what we will have to do is wait and see what Google self-assess. We will obviously monitor that. We will risk assess it. We will inquire as we would with any business if we have concerns about it. I think when you look at how activities should get rewarded, there are a number of methodologies approved by the OECD. Some of them can be like a cost-plus methodology, but you can also look at, particularly in activities that are marketing related, what is a commission on sales that you would expect that kind of activity to get. And those are the kinds of methodologies that we've looked at in this case and we'd look at in similar cases. But what Google will do in the future, we will have to wait and see.
Now, we heard in the last session as well that the diverted profits tax is not going to apply to Google, and if I've understood it, it's because they've paid their tax. Hang on, let me finish. I'm going to go on. So it seems that only those companies where there is a concern that they're not paying their tax, that this legislation would be applied. How much do you think the prospect of being caught under the diverted profits tax led to a settlement at this time?
Okay. Well, the application of the diverted profits tax to Google in the future, again, remains to be determined. We have agreed that it does not apply to them for the last 3 months of their accounting period to 2015 when it was in force. What the diverted profits tax does is it says that if we are not getting full value for the activities and assets carried on in the UK because of some contrivance that has been put in place, then as a backstop we can get the diverted profits tax instead. And it is set at a rate that is higher than corporation tax because the aim...
25%, isn't it?
Correct, yes. And because the aim is to encourage large businesses not to try and avoid their corporation tax in the first place. So what we expect to see, and what indeed we already have seen, is large businesses becoming risk averse as a result of that and starting to change their transfer pricing arrangements and pay more corporation tax so that they don't have to pay.
So it does indicate, and I mean, look, I think there's nothing wrong with the diverted profits tax, that there is clearly contrivances going on in a way that actually denies countries like the UK or France or elsewhere a fair share of what the tax should be paid.
There certainly are some contrived arrangements out there which it's intended to tackle.
Dame Lynn, could I just ask you a couple of questions, please? You mentioned before, actually at the start of the session, that I think you said that you sought permission from Google to share information with this committee concerning their tax, and I completely understand the legalities around that. Have you ever sought permission from Google to share more detail with government ministers about the tax, the settlement or any other tax arrangements regarding Google?
No, and both this committee and ministers have had to put up with me saying over and over again, the Act says this and this is what we do. So what we do, and I think Google indicated in this case, is with their permission, we told ministers shortly before, literally, the day before, that there was due to be a press release by a big company the next day. And when Google indicated, I think both to the shadow minister as well as to our ministers, that they were making it, we provided a copy of that. But we don't...
So a copy of what? A copy of what?
Just the news release when it was issued.
Oh, right.
So we don't...
So you provided a copy of Google's news release?
Well, to our press colleagues. But I mean, it was available, and I think from what Mr. Britton said, they had already done it anyway. So what we don't do, and we never do, is share any taxpayer information, either with ministers or with Treasury colleagues. And so we have a very strict rule about that. And indeed, we try to operate within HMRC on the basis that we only share.
That's very helpful, because I think you said that you, whatever it was, an embargo press release, a day before, let's say 20...
No, I don't think we even shared the embargoed press release the day before. I think we just told them that there was going to be an announcement by the company.
You told the press... Ministers.
We just said tomorrow there's going to be something, in the news. We didn't say who, and we didn't share the details.
You just said there's something in the news tomorrow?
Yeah.
Really?
Yes.
So, okay. So
Google, meanwhile, had been doing the briefing themselves directly.
Well, yes.
But did anyone to know that?
But that's up to them.
But...
Okay, so what I'm trying to get at here is the point at which Google publicly announced the settlement. It clearly showed that the Chancellor was, seemed to be ready for that, because he was, I think, tweeting at midnight or something, I think, on the day from Davos. And then in his speech, made a big deal. You would have heard me quote a section of his speech in the last session. We've got Google to pay taxes. I think it's a huge step forward, and addresses, public anger. What coordination was there with HMRC and the Chancellor and his office around the deal? Because he then went on to say, I hope to see more firms follow suit. I think it's a big step forward and a victory for the government. That sort of must indicate that he must have had some sense of what was involved in the deal. How could he say it's a victory and it's, a great step forward? Well, given that, if I was a minister, I'd be saying 130 million, is that really good? So what is that made up of?
We don't write the Chancellor's press releases. I don't know exactly what he meant by his tweets. What I would say is I think we feel that the work both Treasury and ourselves have done in relation to the OECD work, the BEPS work and the diverted profits tax is part of what, as Jim has just already said to you, is bringing about a change in behaviour. We are rather proud of that. If the Chancellor is as well, I think that's a good thing.
So you're saying there was no coordination, there was no briefing with any Treasury officials?
We have not given ministers, even
working for the
now,
Chancellor or any other minister, about a heads up on the announcement from Google?
No, and we have not given Treasury the information we have given you about taxpayer confidential information.
I ask?
Because we feel that is for you to publish if you wish to.
Thank you. Can I ask, Mr. Britton acknowledged he didn't deny it, that there have been a huge number of meetings, 20-something odd meetings between Google and the government over the last 5 years. He also indicated that possibly, even if it wasn't the substance of the meeting, there might have been a question and answer a bit about the tax situation in Google. Can I ask if any of those meetings an HMRC person was present?
No.
Not at all. Okay. Thank you.
Nor did I. I will vouch for the fact that when you do a job like this, people talk to you about tax.
But the answer is no. The answer is no. We've got to clear up. I'm just going to bring in David Marrett and Stuart Jackson. A couple of quick interventions before moving to Richard Bacon. David Marrett.
Mr. Harlow, you used a great phrase a few minutes ago, actually, when you were talking about penalties and corporate. You used that you are looking at the regime as it might apply to habitually aggressive tax planners. And presumably what you meant by that was that you might have a different penalty regime for people of that type. In your opinion, is the way that Google has set themselves up in the UK and the way that they have conducted themselves in the last few years, does that make them a habitually aggressive tax planner?
Well, the legislation, which is in draft at the moment, sets out a number of criteria that will apply. Our aim when working with large businesses is to impress upon them some of the things I think that the committee have tried to impress upon them today, which is that reputationally it is in their interests to take a conservative, low-risk approach to their tax planning, and that also means that we don't have to conduct very long, expensive investigations of them. So the aim, so how this will work is where we identify a large business who we believe is habitually understating their tax because they are being aggressive tax planners, we will first of all put them on warning that you will go into special measures if you don't change your ways. And if they are put in special measures and they then continue to submit returns which, when challenged by us, are shown to be incorrect, they will not be able to claim as a defence from paying a penalty that they took reasonable care and they took expert advice.
That's a good explanation. It didn't answer my question.
I can't say whether
reluctant to do.
Well, I can't say whether in the future that will apply to Google because it will depend on how they behave in the future. Let me ask the question
a slightly different way then. I mean, clearly you're at the forefront of this legislation, which seems sensible legislation and a good thing to be doing. It's reasonable perhaps that you can't say X, Y and Z are. But given what we've heard from Google this morning and in other times, would there be a candidate that you might look at under this new legislation for being a habitually aggressive tax planner?
Yes, so we'll have a risk assessment process which looks at who are the high-risk businesses on which we need to focus. It will be, I believe, a very small number because we have seen and continue to see a change in behaviour amongst large businesses, but it depends on how they behave in the future.
Google's company structure, they admitted effectively, didn't really change and has not changed, and yet it's taken you 6 years to come to this agreement, mainly around transfer pricing and the permanent establishment issues. Don't you think that's a hugely long amount of time to not really permanently settle the regime in respect of companies like Google?
It was a long amount of time because we had to be very thorough and painstaking, and because we had to look at relatively novel issues that arise from digital companies and share our thoughts with other tax authorities. When you say nothing has changed, whilst their basic tax structures remain as they were, in fact, the nature of the activities that people in their organisation do has changed, the way their customers behave has changed, and of course the scale of what they do has changed over that time. So, for example,
not the structure.
But not the basic structures.
I mean, they invited us to, with reasonable evidence that, you know, Dublin was full of multilingual people, which is why they went there, and nothing to do with the tax regime, which is obviously nonsense, really. Can I, one specific question, going back to Ms. Brock's question about how you treat people with fairness and equanimity. Did you ever consider, or would you ever consider, in this case, invoking Section 396 of the Companies Act 2006, that directors should always give, quote, a true and fair view of the profit or loss of a company, unquote? That's a legal obligation. Does that ever come into your estimation as to whether it would be prudent to use that?
It does potentially. Obviously we're not the regulators of company law, and that would be the Financial Reporting Council. However, we do have a power to disclose taxpayer confidential information to that regulator if we believe that directors are not showing true and fair accounts.
So not filing proper tax returns and making timely payments of tax based on all sorts, but based on evidence that this committee has found of discrepancies between accounts given on things like LinkedIn profiles and pay slips, you wouldn't consider that to be a prima facie case of a contravention of that particular part of the Companies Act 2006?
I'm not an expert on company law, but I believe what you said goes to the published accounts, not to their tax compliance. We are the regulators of whether people fill in their tax returns correctly, and we've got a whole range of powers that we can deploy if they do not. We do also, because we rely heavily as a starting point on the accounts, we do also have a power, if we have any concern about accounting, to involve the FRC.
Okay, Richard Bacon.
Mr. Harron, This 6-year investigation must have cost quite a lot of money. How much?
As I've said, I'm afraid I don't have information that enables me to calculate how much, but you are correct. It is a very resource-intensive process for us.
How many transfer pricing experts do you now have?
We currently have 81 transfer pricing specialists on our central team, and of course there are other people in the organisation who are not specialists in transfer pricing but are trained to conduct the inquiries.
What proportion of those were recruited externally for their expertise?
I don't have that information. I know that we have increased the staffing of that team by 25% in the last couple of years, and certainly some of those recruits have been brought in from externally.
When we last discussed this, I'm sorry, Dame Len.
I think around 120 people have been taken into large business from the private sector over the last 3 years. That may not be an absolutely accurate figure, Mr. Bacon, but it's around about that.
Have you retained them all?
Yes, at the moment. I was just wondering whether it was worth mentioning the size of large business overall, which has also increased since we spoke to you in 2012.
Yes, so the Large Business Directorate looks after the tax affairs of about 2,100 companies. I have 2,447 full-time equivalent people in there.
I'm really interested in the transfer pricing point, because when I first answered the question at 65, the last time it was nearly 80, now it's 81. Yeah. Presumably there's a turnover. Some, you said to me last time, some of them do leave and go off to the big accounting firms.
There is some turnover on that. However, at 81, I'm up to full complement on that team, and we've been able to sustain that.
How many staff worked on the Google case over the 6 years?
It would have varied at different times. There is a core case team that works on a case. They are then supplemented at various stages by economists, data analysts, lawyers, specialist investigators, depending on the stage of the inquiry. So I can't give you a firm number on that. But
you can't give me a fair number.
It's in the tens at any one time.
Yeah, yes. 70 and 90 and 110 and 20 are in the tens. Just depends how many times you multiply 10 by 10. How many, roughly?
Clearly not all 80 are working on Google.
One would hope not. I'm just trying to find out.
At any one time, almost certainly more than 10, less than 30.
Okay.
This is on one company.
On one case, that's varying over time.
More than 10, less than 30. So between 12.5% and 37.5% of your entire complement of transfer pricing specialists.
No, they're not. We don't. That isn't full transfer pricing specialists. If you look at the activities that you have to undertake in an inquiry like this, you've got sort of forensic investigators who need to get at information. You've got data analysts who analyse big piles of electronic data. We get thousands and thousands of documents. You've got economists who are looking at the value created and the prices that you should get for it. So, and lawyers, a whole variety of different.
Mr. Troop, how did you keep the approval of the settlement separate from the negotiations?
I'm glad to be here talking about the process. I was pleased to hear both Mr. Britton say that he was happy we got the right amount of tax under the law, and Mr. Mowat saying that he didn't doubt that. The assurance arrangements which Lynn referred to earlier, which were introduced when I came in 2012, and which I published an annual report on and sent to your committee each year, do remain entirely separate from the casework, and I have nothing personally to do with the casework. The Comptroller and Auditor General looked at the arrangements last year, and he said that the changes have substantially improved the transparency and accountability of large tax disputes. What this means in practice is that if we have about a dozen meetings a year, which I chair with two other commissioners, varying who those other two commissioners are, to which our largest and most sensitive cases come. Typically, the case will involve the preparation by the case team of a quite comprehensive, often running into hundreds of pages of submission, background, summary, questions for decision, but which will boil down to should we accept a settlement or continue with this dispute and proceed to litigation. We will have the opportunity when there are specialist issues coming up to get a briefing on the technical issues, and we've had some, so for instance on diverted profits tax, commissioners were given completely outside the facts of this case a briefing on how diverted profits tax work to make sure that all commissioners taking part in the decision were aware of a novel bit of legislation. We are given time to read the papers in advance, and my office always sets aside quite a lot of my time ahead of meetings to make sure that the papers have been gone through. But that is the first point when I, as Tax Assurance Commissioner, actually see the details of the case. I may have been aware that the actual case was coming up, and may be encouraged to make a bit of time if it's a particularly large case. The actual Tax Assurance Commissioners' meetings are reasonably formal. In fact, the feedback I get is that they're regarded as slightly alarming by the teams who come, and not the entire team of a dozen or so, but the lead workers, and typically between 2 and half a dozen supporting workers will come. We will get them to present the case in a brief way, because we will have had a chance to see the papers, and then we will spend what can be up to a number of hours asking them questions about that, challenging them, and reaching a decision, which may be to accept the settlement, it may be to reject the settlement proposal, it may be to remit it for further work, or even on 1 or 2 occasions to say actually this is not something which should have come to us in the first place. The outline details of all this, as I say, are in my annual report each year.
What this proposal for a settlement of this dispute with Google, was it deemed acceptable by the tax commissioners the first time it was brought before you?
I don't think I go into the details of what's happened on particular cases, but
why not?
The fact that it's gone.
Sorry, why not?
Well, to be honest, I don't think that within the rules of confidentiality I can go beyond discussing anything to do with government affairs beyond the material which we've now shared with this committee that they have agreed that we should share. But we do have cases that come back more than once. I would say that because I have a supporting team that works with the caseworkers on each case, generally case teams are discouraged from coming to commissioners until my supporting team have satisfied themselves that what they're bringing to me is likely to be capable of reaching a decision.
There's an informal Sherpering process to try and ensure quality, basically.
Your phrase, but not a bad one to describe it. We have had cases which we have sent back, and those are some of the ones we've remitted either for further work with the taxpayer, but also remitted for further work on the case because we've not been satisfied. We've either had sufficient facts, but those have been very much in a minority, and the overwhelming majority of cases we have reached a decision at the commissioners' meeting in question and allowed the case team to go back to the taxpayer to either confirm the settlement or tell the taxpayer that we're going on to litigation.
Okay. The phrase Sherpa is not my phrase. It's one that I've borrowed from Whitehall. It's used regularly.
I recognise the phrase. I don't think my team.
Make sure that when the politicians turn up, they don't say the wrong thing. I mean, there's a clear history of this in Yes Minister.
Well, it's why I slightly balked at your use of the word, but I have a team who try and make sure that what comes to me is capable of discussion, not to pre-cook the outcome, but to make sure the material, the quality of the material, which I have to say over the 3.5 years I've been doing this job, the quality of the material.
Let me say, for the avoidance of doubt, Mr. Stewart, I wasn't suggesting for one moment that you were like those people who turn up at international meetings, whom Sir Humphrey was referring to, who wouldn't know what to say unless they were told beforehand. I wasn't suggesting that at all.
I think if the caseworkers were here, they would confirm that I certainly do know what to say, as do my fellow commissioners. And
terrific. Can we talk about your tax commissioners? Can we talk about your fellow tax commissioners for just a second? Yep. There are 6 of you. You were introduced.
3 of them are here.
You were in total. There are 6. Your role as tax assurance commissioner was added following earlier inquiries of this committee, and it was a recommendation. Of the 6 commissioners, you're not all tax experts. Dame Lynn, you've said famously, I am not a tax expert in front of this committee a while ago. Of the 6 commissioners, how many are tax experts?
Well, the first one.
So I think this was.
I'm just looking for a number.
Yeah. So Jim is a tax expert. Jenny is a tax expert. Edward is a tax expert. Nick has been Lodge. I forgot his surname. Has been on HMRC staff for
28 years.
8 years. He has a financial background. I regard him as having tax expertise. I don't think Ruth or I would regard ourselves as deep experts, but Ruth has over the last 3.5 years, nearly 4 years.
That's Ruth Owen, just so we should be
being
clear.
in charge of.
Yeah,
the
just
bit of the
you mean
business
Ruth
that-
Owen, the Director General of
Yeah,
Personal
the bit
Tax?
of the
Correct.
business that brings in most of the tax.
Yes.
So I am the least tax expert, and you'll be pleased to know I don't sit on any of these settlement hearings. I called myself apart from those having put the process in place.
So the answer to my question is 3.5. Mr. Lodge, you said, has got 28 years of experience, mainly financial, not tax.
No,
He's acquired some tax
expert.
expertise, you said, and then you not, and then Ruth Owen, the Director General for Personal Tax, not.
No, I think Ruth has.
Oh, yes.
Ruth is responsible for the bit of the business that brings in most tax. She heads up the policy team that do that, and she has advised on both policy and implementation. So I think over time she has, but I think she would accept that she clearly has less tax expertise than others.
Yes. I'm just wondering, I mean, it ought to seem self-evident that the people who carry the job title tax commissioners are all tax experts, that we shouldn't even be having this discussion.
Well, I think it was a discussion you correctly had back at the end of 2011 that HMRC needed more tax expertise, and it was something I set about improving very rapidly. But I think it is worth bearing in mind that we are also the department of government that is responsible for the most transactional activity. I think the Cabinet Office believes, this is not a figure I have quoted, but the Cabinet Office believes we are responsible for 80% of the transactional activity with citizens. So we are also a business that deeply needs operational experience.
I understand that.
So I think we need a mixture.
I understand that, and that's why you'd have a board. I'm questioning why you'd have tax commissioners who have statutory powers who don't have expertise. Mr. David Green, who ran your Revenue and Prosecutions Office, wasn't an HR expert. He hired a COO to get all that sorted, who promptly hired his wife to do all the HR consultancy. You will remember that case. What I'm curious about is why those functions, and plainly there will be legal, IT, HR functions that aren't to do with tax expertise, why tax commissioners, whose job presumably is quite closely related to tax, why they aren't all tax experts?
No, I'll hand over to Edward in a minute, but I think what I would say is I think it is important to remember we are responsible for implementing the functions of Her Majesty's Revenue and Customs, and I think that...
You mean statutorily?
Yes. I think it would be possible for the person in my role not to be a commissioner, but the way the Act was determined, I would have no authority over the commissioners if I would...
They might quite like that.
They would love it. I think the chief executive of the organisation would find that a little bit more difficult.
Yes, thank you.
But I have taken a judgment that I will interrogate the performance of my tax commissioners, and whilst I don't sit on settlements, I have taken a strong and direct interest in whether as a tax administration we are working effectively, and I think being a commissioner allows me to do that with authority.
Okay.
Thank you.
I think I'm going to bring in the Controller Auditor General now. Just waiting a minute.
To the settlement, if I might, and ask something of Jim Harrow. I wasn't clear. I mean, one of the biggest components, looking at Google Group worldwide, the big component of moving charges around appears to be a sort of royalty related to intellectual property or intellectual property exploitation rights, I think, roughly speaking, if I've got that right. Were you able to look into that? Were you simply looking at the relationship between Ireland and the UK, or were you able to look into how those intellectual property rights are built up from what we've often heard of as all the software engineers in the US? Did you get into that area of how that's charged? Or is that something that relates to, you know, we were listening, Google sounded as if they thought the US tax authorities were fairly relaxed about the Bermuda Group. Do those charges and their build-up get really rigorous examination in the US? Are we to really believe that? And did you have a chance to look at them directly, or were you taking that slightly as a received item? I'm not trying to lead you anywhere, I just want to learn.
I mean, I can't comment, and I don't actually know what the IRS do in relation to that. It is clear from the filings that Google have made that they are under inquiry by the IRS for something. In our case, Yes, first of all, we do look at and investigate the wider arrangements so that we understand how the whole global group sees its profits allocated to its different functions and assets. But when it comes to looking at what is subject to UK tax, what we focus on is what are the activities carried on in the UK and what are the assets carried on in the UK and what should the value be that attaches to those. Relevant to that is an understanding of what are all the different components of this group that produce value. I think, one or other of the two witnesses that were here before said that, in their view, the big value in Google is that generates a sort of economic rent is the intellectual property rights that group has developed through its engineering work. But that's what we do. We do look into all of that.
So, just to make sure I've understood your answer correctly, so what you're saying is, in fact, that was slightly, you wanted to make sure it's added up, computed reasonably, but you weren't in a position to go into a detailed examination of how those rights are built up. I'm not finding fault with you, I'm just asking to be clear.
Ultimately, we do have, when we deal with groups, they will often try to constrain the information that we look at, and indeed the information that they will give us, by saying that is not relevant to what you have to look at, which is the activities that we carry on in your country. We do have other means of getting that information from other tax authorities under our double taxation agreements, and shortly through country-by-country reports under the OECD BEPS project. So we do not allow ourselves to be constrained by the information that the group will give us, but ultimately what we are looking to do is tax at full value the activities carried on here, and not, for example, police their global tax compliance.
Of course not, of course.
Can I ask you, Mr. Hara, as a result of what we've learned from the Google case, have you developed more of an expertise within HMRC on digital-only companies, following on from what the Controller and Auditor General has said, such as LinkedIn and Facebook and Google, to try and work within the OECD aspiration, which is a simpler, fairer tax system? Are you now better prepared for dealing with that very specialist area of tax policy?
I believe we have developed a greater expertise in digital companies as a result of this and other work that we're doing. And as I mentioned earlier, we are part of an international project called the E6 project, where we are collaborating with 5 other major tax authorities to share our intelligence and the arguments that we deploy and what we are learning about these digital giants who of course operate in all of our jurisdictions. So together with those tax authorities, we are all building up our knowledge and understanding of how they operate, right, and what the tax issues are and what the arguments are.
Okay, well, either you or Dame Lynn, you anticipate my next question, Mr. Hara, which is about the tax settlement vis-à-vis other European Union regimes and jurisdictions. Have you had conversations with your counterparts in Italy and France about how they come to such radically different figures to you? The figure quoted is that allegedly French officials were close to receiving the equivalent of £380 million from Google, and in Italy, for the period 2009-13, the equivalent of 173 million, not for 10 years, but 4 years. Are you meeting them and are you finding out what their methodology is?
We do have regular conversations with them, and I think if you don't mind, I'll ask Edward to answer that one. I think just to say, as Jim did say earlier, we have shared quite a lot of information about this settlement with colleagues so that they can base what they are. And although it is a settlement, if we found that there was material information we had not known, we would be able to go back and revisit. Okay, so this is global cooperation, I think, at its heart.
Well, Edward True.
I was just going to say that Mr. Hutchinson had said to you this morning that they had never paid a higher settlement outside the US than they have paid to the UK. So, I think you just have to take that, and as he said, he also said that they were figures, not facts, that you had been...
Well, I'm not asking about his evidence. We've heard his evidence. Well, I'm asking you directly.
Have we talked to the French?
Why? Let me ask a very simple question. Why, given it's obviously the case that the French market in terms of sales and profits for Google are significantly smaller, are they allegedly paying this figure of £380 million equivalent, and I'm asking you, are you learning lessons from that?
You
seem to be rubbishing the French tax authorities as well.
Jim's people have a lot of communication at a working level with a number of tax authorities. We have communication at senior levels. Jim's described the E6, which is a cooperation of 6 countries, but you used the word allegedly, and I think you just have to take what's been said by Mr. Hutchinson.
Yeah, but what's your evidence? You're at the cutting edge of this. You are working with these other tax authorities in different jurisdictions.
Well, I'm not quite sure what your question is.
My question is it's all very well you say, well, the other witness says it's not true. I'm asking you,
we cannot share information about anything we receive taxpayer confidential, and we do not routinely get information about settlements outside the UK, but we will share information on particular taxpayers under the arrangements. And as Lynn has said, if we receive information in relation to a settlement on any of our taxpayers which gives us facts which we think are relevant to a settlement we have already made, we can, if those facts are not the facts on the basis of which we have settled, go back and reopen. So if as a result of anything that goes on internationally, and we will share information where we possibly can, we get further information which allows us to go back to any taxpayer, you can be assured that Jim will make sure that happens.
Yeah,
Can I just add that, first of all, under our treaties, our double taxation treaties with other countries, both parties do commit to exchanging information. In those treaties, it is clear that that is confidential, so we are unable to disclose what information we get from other tax authorities. Furthermore, in the case of European tax authorities, there's European law that requires us to share information. So I believe we have a good level of collaboration with other tax authorities and a good level of understanding what they are doing, and they've got a good understanding of what we are doing. I take what you say, that there are allegations that they are paying more in other countries. The previous witness has said categorically that that the UK's is the largest settlement outside the US.
Okay, can I say we're confident that we have got the full tax that's due. In a sense, we've made the decision based on evidence, and we've made the settlement.
Okay, but
nobody else has.
In French and in Italy, there was a raid by the French tax authority on Google's offices in June, in 2011, we understand, and it was the Italian finance police believe the company no more. So, do you have contact with? Jurisdiction. It's not an equivalent necessarily to HMRC in some of these countries. And Mr. Jackson's talked about the links with tax authorities. Do you also link with those sort of bodies as well?
I mean, we have working relationships. We've discussed before, I think the last time I was here with Jenny actually, that
Jenny Granger,
that a number of other jurisdictions have different procedures to us, and start sometimes in a more police environment.
But my question is, do you have contacts with those police?
Yes, of course.
I should say,
Mr. Hara.
I should say, whilst I talked about tax authorities collaborating, those treaties are between countries, not between tax authorities. So that country is obliged.
I've got one more question, if I may, Chair, and that's it for me. Obviously, you've heard from Mr. Mowat and others about the sense of anger and bewilderment and misbrock from so-called ordinary taxpayers. In order to assuage that to a certain extent and yet comply with your legal obligations, do you think you might reach a point where you could publish anonymised agreements, deals or settlements relating to these big corporate cases, so that you keep the names secret, but that the methodology is out there, and there is obviously greater openness and transparency in that respect?
Yes, so generally I think we are trying to be more transparent. We've talked with you on a number of occasions. Jim puts out information about schemes that we've challenged, as does Jenny. But the annual report from Edward does just what you just said. It summarises the overall settlements he's reached. It puts a value to them. We committed, I think actually it may have been you, Chair, that said, can you publish aggregate information? It was when Gus O'Donnell came to the committee, and there is quite a lot of information there. We would be more than happy to have regular meetings with you on that report, and we could talk about generalities. We have tried in the information we put on gov.uk on Tuesday, to use some EGs that will help people understand
Well, I
this
have to
very
say, though,
complex area.
car sales are not quite the same as internet sales.
Well,
Mr. Jackson's
we
finished.
could put a range up.
I'm going to pass over to Kevin Foster and David Mowat, and then back to Richard Baker.
Thank you, Chair. I was just wondering, as Her Majesty's Revenue and Customs, what discussions have you been having with Her Majesty's Government of Bermuda about some of the arrangements we've been hearing about today?
So this is in relation to them being a tax administration?
Well, in relation to the fact that we've had quite a lot of discussion today, so far today, which I know you sat through and listened to, about ultimately, and we can see the little diagrams via a double Irish, a Dutch sandwich, and then off into what looks like a Bermuda Triangle around tax liabilities. In terms of coming towards the deal, what discussions did you have to try to make sure you had all information that you could have from the government of Bermuda, because bluntly at the end of the day they fly the same flag as we do.
Okay, I mean, I can't disclose details of this specific case. However, the UK does have a tax information exchange agreement with Bermuda, whereby they commit to giving us information that we need to conduct our inquiries, and they do provide information to the UK under that agreement. So whilst multinationals may place assets there because that is a tax efficient thing to do, it is not a hidden or non-transparent thing from our point of view.
And they'll be part of country reporting?
Okay.
And they'll be part of the common reporting system to disclose information.
92 countries from 2017. So, I think Jenny's called that a game changer. We genuinely think it will be.
Wait to see. I suspect some expensively highly paid experts in the companies may still run rings around the tax officials here and elsewhere.
Chair, I would challenge that, and I think Ms Flint used the term outmanoeuvred. I believe what you're seeing here is a leading edge application of tax expertise, both in Jim's area and in Edward's tax assurance area. We don't get outmanoeuvred by these big firms. We make them pay more tax, and I think if I'm honest, I would like to see a little bit more recognition of that. I think we have a fine set of tax inspectors who do an extremely good job.
And I don't doubt there are a lot of very good individuals in HMRC all trying to do the right thing, but
And
we know that these big
tax.
companies, as we've discussed before, have a lot of resource.
They may, but
and
they
Mr.
don't
Bacon has
outmaneuver us.
highlighted the number of just the transfer pricing people you've had for a start. But I mean, I want to before I give over to David Mowat. One of the witnesses, I think it was the tax expert from Google, said it's very common that tax authorities will take a very different view. You've always maintained, Damien, that you don't do deals, but we know with a lot of these things that there's a range of options. Maybe Jim Harrow will answer this. And the company will come to one view, you will come to another, and in the end some accommodation is reached. That's to us is a deal. Do you not agree that that does take place?
I think, first of all, Mr. Hutchinson did explain, I think in response to questioning from Ms. Flint, that there is no pitching of numbers and negotiating or horse trading or dealing around that. You are right.
Well, not a global number, but each bit along the way.
Yes, you are right that in the case of transfer pricing in particular, there is often a range within which the answer can fall, because what you're looking at here is a judgment about what is the value of something. And I mean, I know you didn't like the analogy of a car dealer, but in a very simplistic way, if you were building an extension to your house and you took a quote from 4 builders, you're unlikely to get exactly the same quote from them all. And you can't say one of those is right. What we have in transfer pricing OECD guidelines is a number of different methodologies that you can apply in determining the transfer price. And one of the things that we do is look at what transfer price you might get applying those different methodologies and see where those cross, so that we narrow the range and make it as specific as we possibly can to the facts of the particular case. But ultimately, in transfer pricing, there will be a range within which a transfer price.
I think it's just
fall.
fair to get that on the record that it is not an
It's a
exact,
judgment.
It's not an absolute.
There is judgment, and we'll
There
come
is.
back to it. But David Mowat, and then
I wanted to return very quickly just to this issue of potential settlements in France and Italy. I think you both quoted Mr. Hutchinson in saying that this UK settlement is the biggest ever for Google, but he didn't say that there aren't bigger ones in the pipeline. In fact, he was quite careful with his language and tenses, I thought. But Ms. Homer, you said something very important, which I wanted to just absolutely understand and nail, that if and when French tax authorities or the Italian tax authorities agree something with Google that might, on the face of it, be a better deal than we had here, very clearly you would look at that, and you have the legal ability to open up the deal that you've done and revisit the assumptions that you've made in the light of those transactions if they turn out to be different? This
would be if there were material evidence that had not been made available to us and should have been. So, I mean, I don't think we wouldn't want to comment on any other tax administration's negotiations. But what I would say is that an assertion often reported by several people, I think one has to wait to see what happens.
I mean, let me just push you on that. Then. Let me just push you and your colleagues on that. Let me just push you and your colleagues on that. If the computation that was finally produced in Italy or France took a different view as to the value of intellectual property and the amount, therefore, than say the UK has taken, would that be a material consideration that would allow you to open it up?
I think I should sensibly get Jim to try and explain this to you.
No, I think what would enable us to reopen this is that if facts came to light subsequently that were not disclosed to us during the course of this investigation and they were irrelevant to the value that should have been attached to that, then we can reopen this.
Okay, I guess it's a grey area as to what's a fact and what was a judgment that you took.
But
okay, is there a time limit? Is there a time limit on how long it can be until you can reopen this case?
Not that I'm aware of.
No. Okay, simple answer. Okay, over to Richard Bacon.
Mr. Harrow, do you know how much tax Google paid globally? I'll start again. Do you know how much tax Google paid globally over the last 5 years?
In terms of what they pay globally, I have access really to the same information as you have from their public accounts.
Well, I asked them and they couldn't tell me. They kept on going about this figure of 19%. They kept on saying they were paying 19% tax. And when I asked if it was in the UK or globally, they said globally. When I asked how much is that on which there's an amount that's 19% of it that they're paying in tax, they couldn't tell me. And I was just wondering if you knew.
I don't offhand. I mean, I know that they say 19% is their effective tax rate globally. That's based on their tax charge in their accounts and their profits per their accounts. And as you pointed out, they operate in different jurisdictions with lots of different rates, and that is an average across all the jurisdictions. And I believe the witness said an average over 5 years as well. But I don't have that.
I was looking for a number. Nobody seems to know it. It seems to puzzle me that nobody seems to know this. Google didn't know it. And here you are, after 6 years of an investigation involving between 10 and 30 of your experts at, you said yourself, great cost, and you don't know it either.
But we're not the global tax administration.
I realise that you're not the global tax administration. Given your customer service performance here at the moment, whether we want to inflict you on the rest of the planet is itself moot. But I realise you're not.
Unfair and unjustified.
I'm just asking whether after 6 years and 10 to 30 people investigating it, whether we might not expect you to know the answer to that question, even though you're not the global tax administration.
Well, I think you've asked for that, and Google have agreed to write to you.
Well, I think we're more surprised they didn't.
It will be extracted from their accounts, and it isn't absolutely straightforward to be able to...
I understand that, but you will appreciate it doesn't give us overwhelming confidence that this thing has been settled satisfactorily when neither you nor they can say how much tax they've paid globally in the last 5 years. That wasn't a question.
Sorry, I go back to what it is we are here to do. I mean, we are here to identify the activities that are carried on in the UK, that are taxable in the UK, understand their value and make sure that we get the full amount of corporation tax on those. You've heard from the previous witnesses that they have tax structures in place designed to make sure that they are tax efficient in relation to the US tax system in particular. That is not something that I would like my very expensive resource to be spending quite a lot of time looking at. Their global...
and nor should you need to. I'm just after one number.
I mean, their global profit in 2015 from their own accounts was $17.259 billion. I assume their effective tax rate is 19% of that figure. But I believe they agreed to write to you.
Yes.
So we'll check whether that figure that Jim quoted is the correct one when they write it.
Yes. Thank you.
Okay. Can I ask you, Mr. Harrow, you were named as Tax Personality of the Year last year. Congratulations on that. and you have been, well, you're well paid. I think you were or are the highest paid employee for HMRC. I'm not knocking you for getting a salary. He's not now.
You've made him very grumpy because he's gone and looked at what everybody else is paying.
You've now caused me to check it, and I find I'm the lowest paid commissioner.
I think you're a lot better paid than a lot of your tax but you're well paid for doing your job. So you are an award-winning taxman. Do you think the British taxpayer will sees this tax deal with Google as an award-winning tax settlement?
What I hope the public will see is that HMRC has done a thorough and professional job and got the amount of tax that it can get from Google under the law. And indeed, over the period 2010 to 2015, from large businesses generally, £38 billion additional tax from large businesses. It is impossible to get that amount of money from large businesses without doing a thorough and professional job. That's what I want the British public to believe. Whether they believe that the amount of tax that Google has to pay under the law is fair or not is a matter for them to debate, but it's not a matter for which I can account to.
Okay, but it took a 6-year investigation to get this back tax for a 10-year period. Are you proud of that, the fact that the tax wasn't coming in as it should have done in real time?
Well, tax was coming in during that period.
But okay, not the right tax, whatever the right, but not the figure that you eventually settled on, whether or not.
You're right that, over a period of years, the amount of tax being paid year on year was less than the amount that was due. We have got that tax, and we have got interest on the fact that it was paid late, so the public purse has not lost anything from that. But it is part and parcel of the way we do our work that we inquire into a risk for a particular year. If we believe there are problems in previous years, we go after the back tax. We've got powers to collect it. 6 years is a long time to carry out an investigation, but looking at the level of attention that it is getting and the level of scrutiny, the fact that we've done a thorough, painstaking job, I think, was important.
Well, can I go to Dame Lynn to ask you about this interest rate? Can you tell me what interest rate Google paid on their unpaid tax?
I'm going to have to ask. I don't know.
I'm afraid I don't know it offhand. It is set in statute, but I'm afraid I can't tell you offhand what it is.
Okay, so it's set in statute. So can you guarantee us, Dame Lynn, that no British taxpayer has paid a higher interest rate than Google on any back tax?
It's a statutory rate, so I'll just
repeat. For the same for corporates as it is
for each year, yeah, absolutely.
For any individual,
yes,
as well as for a corporate. So a corporate with a lot of expert tax officials that may have managed not to pay as much tax as they should have done, for whatever reason, in certain years, they'll pay the same interest rate as any of us around this table and the small businesses in our constituency.
Well, except for those people, and there are some where we enter into more generous arrangements to allow people time to pay. So it will sometimes be less. So
you're saying that the ordinary taxpayer, the individual or the small company, might pay less sometimes, but they would never pay more.
But it's a pinnacle, it's a cornerstone of our system that we have one set of rules and we apply them to people. And I think that is something that people should take confidence from. And if I might say, on behalf of the Tax Personality of the Year, I hope people will also hear that this is the largest settlement Google have made outside the US.
Okay, I mean, I have to say, you quoted earlier, I think you quoted the Cabinet Office talking about you as an entity, that 80% of government transactions with citizens are with HMRC.
Yes.
And we've had you in front of us a number of times about basic customer service for those taxpayers. Do you understand, and do you have any sympathy with the frustrations of those taxpayers who can't get through on the telephone and yet see £130 million paraded as a great success story from a large corporate working in the UK?
I think it's very important that every single taxpayer believes that we are treating each of them fairly and under the same rules. And we spend a lot of time trying to make sure that that is heard. I've said here before, I will say again, we never enter into an intention to give poor customer service. We did so in the first quarter of this year. I'm very pleased to say that that has continued to improve. And the performance during the SA peak, not just for people filing self-assessment, but for other customers as well, was seeing some of the highest standards of service we've ever given. Waits of 27
Well, we would hope so.
seconds.
It's a pretty big basic.
It's a very big priority.
Can I just going back to Google for a moment? We've heard, it seems a bit like a Damascene conversion of Mr. Britton, who's talking about the delights of tax simplification and welcoming the OECD BEPS programme. and all the rest of it. And when you may remember, I think Damon, I'm not sure actually who was here then, but in 2012 when he came before us, he was very confident about why they had these arrangements. It was about avoiding tax. It was very clear. It was very clear in his evidence. I don't need to quote it. It's all there written down. Do you think that their sudden conversion to this desire to see simplification coincided with the need to settle with HMRC?
Look, I think it is important that the international work on aggressive multinational behaviour does continue. I do think both my colleagues...
So I'm not talking about that. I was asking you very specifically. Do you think it's miraculous?
I think it's that work that is changing behaviour. I think the introduction of BEPS, I think the introduction of diverted profit tax, I think our approach is changing behaviour. And one of the things we're consulting on at the moment, which I think will further change behaviour, is a proposition that we should expect large businesses to publish annual tax strategies. And I think if they have to explain to people what their tax strategy is, it does have an effect on their behaviour.
Yeah, I think ultimately what we're talking about here is public confidence in you at HMRC to get the money in from everybody equally and fairly. And you make these statements about fairness, but it doesn't feel like that to many individual taxpayers who see these what seem like cosy.
And that's a sadness. I've said before.
So
I wish
you let me finish.
Get everyone to read our tax strategy, and we can't.
If you'd let me finish my point, so you're saying you would like to see companies publish their tax strategy. We're saying, as you've heard from questions
on that at the moment.
If you let me finish my points, and Mr. Jackson, I think it was asking about making sure that there's a greater publication. There's the annual report, but something that's in even simpler form for members of the public to understand. Do you agree that there is a tax confidence issue with the public, and what are you going to do about it?
Yes, and I would just ask anyone that might be watching this, and it's surprising the number of people that do watch the Parliament channel, to have a look at the gov.uk piece that we put out on the 9th of February. It's short, it's explanatory. I hope it will
Well,
give
I have to say,
confidence.
I don't want at the end of a hearing to get into that.
Well,
It was quite extraordinary, but it was very highly supported by Sir Jeremy Hayward, I noticed. But anyway, I'm going to bring in Karen Smith very briefly, and then...
I'm pleased to hear about your tax strategy, but I'd be interested in your views about the local Bristol Clinical Commissioning Group in my area is currently changing its constitution under threat of a legal challenge by private healthcare companies about awarding contracts to private healthcare companies where the rules are not fair if they are seen to be offshoring their tax. What's your view about that?
So the Cabinet Office has some rules about ensuring government, when it puts out competitive tenders, checks and requires evidence that companies are compliant with our tax rules. I think that's a good thing.
But do you think that the local NHS should be changing its constitution to allow companies to feel that they can do that and have
I'm not cited on the particular case. I think if Jenny Granger were here, she would tell you that we treat public sector organisations as taxpayers in just the same way we do others. If we see them doing things that we think are moving towards tax avoidance, then we intervene with them as we do anybody else.
So would that come within your latest tax strategy?
We have a team that looks at public sector organisations.
But the proposition that's in the draft legislation in Finance Bill 16 is that large businesses must in future publish their tax strategies. So it's specifically targeted at large businesses.
Can I just finish on this point? We've talked a lot about transparency today. You've talked about them publishing their tax strategies. That's a good start. But you have often talked about the absolute need for confidentiality, or you wouldn't be able to seal the deal with those companies to get tax in for other taxpayers. But you don't give us evidence for that. You simply assert this. Have you got any evidence to prove that confidentiality is actually going to get more tax in than if the sunlight was shone on tax affairs much more clearly?
So confidentiality in our tax system has been there since we've had a tax system.
We know the background.
We have increased transparency throughout our period, and as I say, I'll refer again to Edward Troop's annual report. I think if Parliament chooses to change that base, we will be able to measure a before and after. I see no other way of knowing. What I will say to you is it is the norm, by far and away the norm, of tax administrations throughout the world. Even the very limited number that do something else, publish a very small amount of information. For instance, a couple of Scandinavian countries publish tax returns. They still don't publish the tax that's paid. I think encouraging companies to be more explicit about their tax is a good thing. I think I first said that here very soon after I arrived. But I think the question about whether we put everybody's tax information out and whether that would help or hinder our ability to collect, our view is that being able to talk with the taxpayer in a way that does not make them feel by showing us something they're exposing their competitive advantage to their competitors. I think it does help us.
Well, we recognise there may be bits of information that are difficult, but I think people are not convinced. I think we know, from people who contact us, our constituents, there's a lack of confidence in the system, and that worries us, because in the end we want
like
HMRC to have the confidence of the people it's serving.
So would we.
But thank you very much indeed for coming along. As always, transcripts online in a couple of days, and the report will be out in the next couple of weeks. Thank you very much.